Now, a couple of lawyers have written an opinion piece that appeared in the New York Times about Trump's illegal action. See, even appointing this crazy fucker, what's his name? The acting Attorney General, Whitaker, is unconstitutional. Plus, it's part of Trump's obstruction of justice. You know, these fucking Republicans in the Senate, how many impeachable acts must President Pig do before these unconscionable bastards in the Republican Party bring it to an end? Neil Katyal and George Conway III. George Conway III is the wife of, or the husband of Kellyanne Conway, Donald Trump's close advisor. This is what they wrote. By the way, Katyal and Conway are both lawyers. What now seems an eternity ago, the conservative law professor Steven Calabresi published an op-ed in the Washington Journal in May, arguing that Robert Mueller's appointment as special counsel was unconstitutional. His article got a lot of attention, and it wasn't long before President Trump picked up the argument, tweeting that, quote, "the appointment of special counsel is totally unconstitutional," end quote. Professor Calabresi's article was based on the Appointments Clause of the Constitution, Article 2, Section 2, Clause 2. Under that provision, so-called principal officers of the United States must be nominated by the President and confirmed by the Senate under the Senate's advice and consent powers. Calabresi argued that Mueller was a principal officer because he is exercising significant law enforcement authority, and that since he has not been confirmed by the Senate, his appointment was unconstitutional. As one of us argued at the time, he was wrong. What makes an officer a principal officer is that he or she reports only to the president. No one else in government is that person's boss. But Mr. Mueller reports to Rod Rosenstein, the Deputy Attorney General. So Mueller is what is known as an inferior officer, not a principal officer, and his appointment without Senate approval was valid. But Professor Calabresi and Mr. Trump were right about the core principle. A principal officer must be confirmed by the Senate, and this has a very significant consequence today. It means that Trump's installation of Matthew Whitaker as acting Attorney General of the United States, after forcing the resignation of Jeff Sessions, is unconstitutional. No, it is illegal. And it means that anything Whitaker does or tries to do in his new position is invalid. Much of the commentary about Whitaker's appointment is focused on all sorts of technical points about the Vacancies Reform Act and Justice Department succession statutes. But the flaw in the appointment of Whitaker, who was Jeff Sessions' chief of staff at the Justice Department, runs much deeper. The flaw. It defies one of the explicit checks and balances set out in the Constitution, a provision designed to protect us all against the centralization of government power. If you don't believe this, then take it from Supreme Court Justice Clarence Thomas, whom Mr. Trump once called his favorite sitting justice. Last year, the Supreme Court examined the question of whether the General Counsel of the National Labor Relations Board had been lawfully appointed to his job without Senate confirmation. The Supreme Court held the appointment invalid on a statutory ground. Justice Thomas agreed with the judgment, but wrote separately to emphasize that even if the statute had allowed his appointment, the Constitution's Appointments Clause would not have. The officer in question was a principal officer, Thomas concluded, and the public interest protected by the Appointments Clause was a critical one. The Constitution's drafters, Justice Thomas argued, quote, recognize the serious risk for abuse and corruption posed by permitting one person to fill every office in the government, end quote, Justice Thomas. Which is why, Clarence Thomas pointed out, the framers provided for advice and consent of the Senate. What goes for a mere lawyer for the National Labor Relations Board goes in spades for the Attorney General of the United States, the head of the Justice Department, and one of the most important people in the federal government. It is one thing to appoint an acting underling, like an acting Solicitor General, a post one of us held. But those officials are always supervised by higher-ups. In the case of the Solicitor General, by the Attorney General and Deputy Attorney General, both confirmed by the Senate. Mr. Whitaker has not been named to some junior post one or two levels below the Justice Department's top job. He has now been vested with the law enforcement authority of the entire United States government, including the power to supervise Senate-confirmed officials like the Deputy Attorney General, the Solicitor General, and all United States attorneys. We cannot tolerate such an evasion of the Constitution's very explicit, textually precise design. Senate confirmation exists for a simple and good reason. Constitutionally, Matthew Whitaker is a nobody. His job as Mr. Sessions' chief of staff did not require Senate confirmation. And parenthetically, yes, he was confirmed as a federal prosecutor in Iowa 14 years ago. But Mr. Trump can't cut and paste that old lapsed confirmation to today. End of parentheses. For the president to install Mr. Whitaker as our chief law enforcement officer is to betray the entire structure of the United States Constitution, our charter document. So who in the legislative branch or in the executive branch is going to step up to President Pig and say to him, you can't do this? Who in the Congress is going to say, well, whatever Whitaker decides to do can be ignored because he is not constitutionally or statutorily correctly appointed? So his appointment is meaningless. Meaningless. If the House says to Robert Mueller, we want you to come now and testify in front of us, and if you don't come, we'll issue a subpoena, because this is crazy. We have an insane fuck who's heading the government. And if Mueller were to say, okay, I'll be there, And if Whitaker were to say, no, you won't, Mueller legally, constitutionally, can say, sit down and shut the fuck up. I'm going to address the House. Now, you talk about a constitutional crisis. Here it is. Here it is. Now, there's a way around all this, of course, sadly. All this President Pig has to do is submit Whitaker's name to Congress, to the Senate Judiciary Committee, I should say, for debate, for hearings, and then for a vote, and then to the full Senate. And the pigs in the Senate, the Republican swine, the cowards, would go ahead and do that. I'm sure they would. So in the meantime, and I know Mueller knows this, and I know the Democrats in the House know this. In the meantime, in the time it would take to do that, it would seem to me that Mueller has got to move now and move quick and present all the indictments, all the evidence that he has dug up about this criminal son of a bitch that's running the country. Will Mueller do that? Your guess is as good as mine. Jesus fucking Christ. Look what Trump is doing. Look what he's done. Look what he continues to do. And in the background of all this, his Nazi minions continue to fucking kill people. Send bombs through the mail. And these dirty sons of bitches on the Fox sewer continue to promote it and encourage it. Jesus, God in heaven. So let me ask you again, the people who decided not to vote for Hillary because, you know, she makes me sick. Oh, fuck her. How do you feel now? I know you don't give a shit. You couldn't care less what happens to your country. If you didn't know Trump was going to turn out like this, then you're a bigger fucking idiot than you showed by voting for Jill Stein or Abe Snake or whoever the fuck you voted for and allowed Trump to become president. Are you happy? You are co-conspirators in the destruction of this country.